if there's a possibility that personal information could be compromised, then that is the definition of harm to a person's personal information. Executives care because this is now a board level type of issue. Cybersecurity is a board level issue. It's not just an IT issue by any means. Keystone Pro is the way to make sure that you are not in a position where you cannot answer the "how did you not know this" question. We don't know everything, but we can certainly follow a very detailed, diligent, highly defensible structure that gets us there.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Iran Kahana. Iran Kahana is an AI, cybersecurity, and intellectual property lawyer, as well as a fellow at Stanford Law School, a member of the advisory board of Stanford Law School's Stanford Artificial Intelligence and Law Society, and an adjunct professor of law at the University of Minnesota Law School. Iran counsels clients on a wide variety of matters related to AI, cybersecurity, privacy, technology law, trademarks, patents, and copyright issues. He also serves in a variety of cybersecurity thought leadership roles and works closely with the FBI, Department of Justice, Secret Service, and colleagues from the private and academic sectors to set, promote, and sustain cybersecurity best practices. The webinar that you're about to watch will be approximately 1 hour, and time permitting, Iran will be taking questions from the audience. If you have a question that you'd like to submit for us to answer towards the end of the presentation, you can always do so by clicking the Q&A button in the control panel at the bottom of your screen and sending it in there. Now, without further ado, here is Iran to discuss cybersecurity and AI governance assessments, privacy compliance under the CCPA, and beyond.
Thank you very much, Nina. Welcome, everybody. This is now my second presentation on this topic. It's been really kind of an interesting ride on this, and you'll understand a little bit more as we go through this. So, as Nina said, I'm an attorney at the Maslin firm. My work is, I would say the headline is intellectual property. I do a lot of tech law at Stanford. My work is studying the intersection of AI and the law. And I've been doing that for just short of 17 years. So it's been quite a journey, especially since ChatGPT came out. And what before was something that many people were not interested in, meaning AI. Now everybody seems to be interested in it, at least in the legal profession. And so this has become a very interesting area to work in. Also, my work at the University of Minnesota Law School, where I teach a class called AI in the Law, and the class is based on what I do at Stanford. So everything's connected, and even what I'm showing today and discussing today is connected to AI because the tool that I will be talking about was created with AI. It's a tool, like I will say this again, but this is a tool that I wish I had years ago, many years ago. But I may do with other tools, like I used Excel to create lists and things like that, but it had no intelligence, it had no capabilities. It was just a very primitive, really, it was kind of a laughingly primitive format when I think about it today. So this tool is the practical aspect of this presentation. I'm a big fan of being practical. So even what I do at Stanford, yes, it's totally academic. As one of my former bosses many years ago said to me, that was a totally nerd move, by the way, which is a comment I took as a compliment. Yeah, it is a nerdy academic move, but in any event, I try to navigate it into practical things. And what I do at Stanford in many ways prepared me to be what I am showing you today. I will provide my contact information. So if we run out of time, please feel free to reach out by email or connect with me on LinkedIn. I'll do my best to answer questions. Yes, the tool that I will show you is a licensed. You can license it, and you can reach me about that if you're so inclined. And I will provide the contact information for that. Screen, we're going to be moving, just by the way, we're going to be moving between two screens. One is the PowerPoint, and another one is the actual form that I will be showing you. The form is called Keystone Pro. That's the name I gave it, had to have a name. And so that's the name I came up with it for it. And so we'll be moving between two windows here. As we go along, I will explain things about the CPPAs, what it is that we're focused on, why are we talking about the CPPA, what is the game changer that it's presenting us with. And then I will move into the Keystone Pro form and show you how that takes care of what it is that the CPPA is requiring. So here we go. Hopefully everybody can see that. So and there you go, as I said, my contact information. So what I'm talking about with the CPPA is the updated compliance requirements that they set out or sent out in this was in May of this year. And as I read through this, there was a lot of things that were like, wow, this is a real they're really upping the ante, so to speak, in terms of compliance with the CCPA. And I always, like I said, I look at the practical things, and one of the things that um, struck me was the cybersecurity assessment requirements that come from these updated regulations. And as I read them, it dawned on me that, first of all, there's nothing there that is shocking. It's you read it and go, yeah, it makes sense. And actually, there's a lot of common sense in what it's requiring. But the thing that struck me the most is that what I see with the CPPA doing here, I see that extending beyond California, and that's part of the and beyond in parentheses here. So my reading of the tea leaves, or reading between the lines, however you want to frame it, is that we are not done with California. Is the I think the first it's ringing the bell of what is going to happen in other states. And this is not unusual. We've seen other states follow Californians' lead on what happens with privacy. And I think this is just one of those where other states will for sure adopt similar, maybe even more stringent requirements as it relates to cybersecurity assessments. So what I want to focus on is the assessment, or as it calls it, the audit. And what the CPPA says is that every business whose processing of consumers' personal information presents a significant risk to consumers' security must complete the audit. All right. So what is a significant risk to consumer security? And you can digest this in any way you want. You can look at it and read it over and over and over again. I think that what it comes down to is that it really is, if there's a possibility, and I'm putting aside the thresholds of how many consumers we're dealing with, because in my work, that threshold is met almost every time. So this is not an issue. So if this is also in your practice, you need to decide if it meets the threshold. If it doesn't, this is not relevant. But my operational assumption here is that it is meeting the threshold. And so that's where we go from that point. And really what it says is that it's, if there's a possibility that personal information could be compromised, then that is the definition of harm to a person's personal information. So the possibility that will be compromised is quite a it's quite a statement when you think about it. The possibility, part of what I do in my practice is I deal with cybersecurity breaches. Fortunately or unfortunately, well, fortunately for me, because it's a lot of work, but I do them, and I can see that it's not a matter of if, it's a matter of when. So the harm here is just waiting to happen. So the question for us is, what do we do? How do we prepare for that? And this goes, there's obviously the incident response plan and things like that. But I just want to focus on what the CPPA is talking about with the required cybersecurity audits. And so when you think about the audit and when you think about this, what the form does that I will show, I will tease it up a little bit, but then I'll show it to you. Um, the audit has to basically identify, assess, and document the client's cybersecurity regime. And it's they don't provide a whole lot of information about that. They say, look at MFA, which is multi-factor authentication, encryption, and account management. Again, nothing revolutionary here. These are all things that have been talked about by NIST, for example. If you follow NIST, the National Institute of Standards and Technology, they've been around for a long time and have been talking about this for a long time. It's just a matter of, have lawyers been paying attention, in my estimation and in my view, in almost 30 years of practice, obviously not with NIST, but about close to 2 decades with that. um, I think most lawyers are not paying attention to NIST, and they should be. And it's one of those things that is just available to everybody. It's free. And if somebody's not paying attention to NIST, it's just because they decided not to. It's not relevant for their practice, but it's something that's available. But I will say this, and this is hopefully a takeaway for you, is that if you're going to get into NIST, it's something that requires quite a bit of training on. NIST is not something that you just pick up and go. Um, Maybe it's just me, but to me, it took a long time to work with it and really dig in and understand what it says, why it says it, and how to make it all operational. And everything that I'm talking about with respect to NIST and understanding NIST to the greatest amount of detail that I can. And this is an ongoing process. It's not ending. It's continuous. Part of what I call a continuous learning and improvement cycle. So what NIST has to say is something that you will see very clearly, I hope. I will do my best to show that in the form that I am going to be showing you here today, the Keystone Pro. So with that, I just want to say one thing. Let's see if I can show you quickly the, let's see, stop sharing this and let me move over to the form itself just to show you what we're talking about. So this is the Keystone Pro form. Again, I'm happy to do a demo if you reach out to me and we can discuss this. But this is the form itself. There's a progress bar at the top here. And basically, it's pretty self-explanatory in terms of what it is that we are seeking to fill out and capture from a vendor. Again, keeping in mind, our goal is to comply with what the CPPA says, and this form is the way we get that done. And the sections that are in here basically guide you into what you need to be thinking about. And it's there's quite a bit here to digest, but it's not difficult to use and it's not difficult to understand in my view. Again, I created it in terms of a tool of what would I like to have. And the beauty of being able to do this now is that I can create exactly what I want and I can modify it exactly the way I want, and make it fit exactly the specific application that I'm working on, whatever it be. This version of Keystone Pro is, I think, one that covers most of what I would ever need to do. It's certainly one that captures what we need for the CPPA. But I make modifications to this form as I need. It's easy to do. I've spent a lot of time creating the framework for it. So making tweaks to it is something that I do based on my understanding of what a client needs, and I'm able to capture that. Now, you will see I stalled, so to speak, on a section here, which is the risk assessment summary. And I think this is one of the more important parts of the form, because I'll digress just a little bit. I spent about, not quite, but about half of my career as an in-house lawyer. And so I'm very familiar with working with the business teams, and especially the C-suite, and especially the CEO, and occasionally with the board. And when I created the risk assessment summary, I wanted something that shows to executives in a very clear picture, what is it that we're dealing with? What, in terms of risk, because that's really the game, the name of the game here. We are in the business of risk mitigation, not risk elimination. And that if that's not clear to you as a lawyer, hopefully it's clear now. We cannot eliminate risk. We can also always just say, well, we can only say, the best we can say is that we have a low risk. We can't say there's no risk, but we can say there's a low risk rating, which is, you can see on the right hand there. And that's the best we can get to. And we just are in the business of mitigating risk and saying, well, what are the compensating controls? And we'll talk a little bit more about that. So this is something that I wanted to have in my hands, and I will say this periodically through our hour here together. I treat this form as a script, and this is the script with which I talk to my clients, and my, essentially the stakeholders are, many different types of stakeholders. I have, like I said, the executives, obviously the general counsel, if I'm reporting to the general counsel. I have the board, I have regulators, I have even potentially in litigation. What is it that we saw? Regulators will ask, how did you do what you did, and what did you look at? And I'll say this, producing the results in this form, and I want to show you what that really means. And you could see maybe on the bottom here, it says generate a JSON. A JSON is a file format. It's human readable and machine readable, and it's something that you can export into a variety of different applications that would can interface with that information. And again, because it's human readable, it's not, if you don't have an application, then it's not like you are missing something there. And for smaller practitioners, if you're a solo practitioner, you wouldn't have a governance, risk, and compliance platform like OneTrust, which a JSON could be exported over there. But the bottom line here is that you have something that is leading or guiding your discussion in a very informed way with the clients. I have a quick war story, 30 seconds kind of a thing. When I was an in-house lawyer, this happened probably more than 15 years ago at least. And I was involved in part of what I did. I was involved with a product and review board in the company. And I remember a meeting where one of the key executives there, was presenting new features in a machine that we were going to roll out. And the CEO asked a question about a feature in that machine, basically comparing it to something that a competitor, one of the main competitors, had. And the CEO asked the executive, said, what about this feature? And I won't get into specifics here, but what about this feature? Don't we have that? And the CEO, the executive, just kind of like froze. And it was just a very uncomfortable situation. And it was clear that we did not have that. The machine that we had did not have that. And the CEO asked the following question, which I've turned actually into a mantra. And the question was, how did you not know this? And I think for me, that was one of those scenarios where you're like, thank God I didn't get asked that question, because the how did you not know this question is, I think it can be quite career limiting, but it's also something that I turn it into a kind of a positive, in terms of I'm asking myself that question. am I opening up myself to a how did you not know this type of um, questioning? And so as we look at this entire structure again, this entire structure of this was not built only to address that kind of a scenario of how did you not know this, but also to really show expertise, show authority, not authority that I'm the lawyer and hear me roar kind of a thing, but this is my expertise and it's built on basically completely defensible uh, um, frameworks. And by defensible, I don't confuse that with defensive because it's not that. And you can see that there are these ovals on the right side of each section. And the ovals are essentially the way we make this defensible. Each of the ovals, speaks for itself. ISO, GDPR, SOC 2, and all these different standards and regulations. And the reason we have these in there, the reason I put them in there, is because I don't want to have a situation where any client is arguing with me, or a vendor is arguing with me, or or some other stakeholders arguing, why do you need this? So, why are we asking these questions? Some of these are more obvious, but some of these are maybe not. And I wanted to make sure that everything that I do in here is tied to something that I'm meeting the requirements of. So if I'm asking about what kind of where is the data residency, right? I see why I'm asking that question. It's under ISO 27018 and GDPR 44 to 49 and SOC 2. And, I can share with you, and maybe you've had the same experience, where you're sitting in a meeting and you're talking about some deployment of some system, and there's a question that I've been wanting to ask that question frequently. Where's the data going to be stored? And you have this kind of, people are looking around the room and like, I thought you knew that kind of a situation. And no, it should be something that we know right up front. There should be no situation where you don't know where the data is hosted. And so in this case, we have the ability to capture that. And we also know exactly what kind of data is being handled, just as an example. I've been in meetings where that too is something that, where I'm asking the question, what kind of data is this vendor going to be handling? What do they have access to? And people just looking around the room don't know. And it's not, I'm not trying to throw anybody under the bus in terms of the procurement teams I work with, the business teams I work with. There are just a lot of things that get missed. People are focused on the contract that they got from the vendor. They're focused on the negotiations. They're not thinking, they're not zooming out of the transaction in order to capture this information. So I think it's very important to have this guide the discussion, because like I said, this ultimately is something that will create the script for us when we need to talk about this. And I think it's not an if, it's a when, because the regulators will come knocking. There could be litigation. There will be all kinds of events that would make this type of data capture something that I think is important for all lawyers to appropriately appreciate and be able to do. So from here, I'm going to move back to our presentation, and I'll move again back to the forum when we need to. So what is my goal here? Hopefully you've kind of already understood the goal. It's to turn something that's abstract, the CPPA, regulation in terms of a cybersecurity audit or whatever you want to call it, and turn that into something that, okay, this is how you get this done. One thing that I dislike is reading regulations and coming out of them, well, I don't even know how this is going to get done. And there's a lot of that going on. And so the how is the form. This is, again, you don't need to necessarily use Keystone Pro. You can use anything that's maybe similar, but the idea remains the same. You need to have a systematic assessment tool that you use in order to, I think, comply with what the CPPA is saying. And if you're not using a systematic tool. And I want to be clear what I say when I say systematic. This is something that is not a one-off. That is not systematic. A one-off is, some people call it ad hoc. That's not good. Regulators don't like ad hoc. It doesn't show thoughtfulness. It doesn't show deliberation. It doesn't show diligence. I think if anything, it's really running very close to negligence. You're just doing a one-off, and this is not the way to run in an important part of the operation, which is essentially the cybersecurity audit. If you're going to do an audit, it better be something that is systematic, that shows that it was very well thought through. So why does this matter? So the CPPA, I think, and if you read the public comments and all that, it's kind of an interesting journey that this went through. But they've added new sharp teeth to the rules. And again, I'm just focusing on the cybersecurity audit here. But it's the what's required here is a very close attention to this. And again, I don't want to use the word systematic too much, but it is let's call it checkpoints. You need to have checkpoints that you are consistently looking at and meeting, and not just skipping over anything. And that's why using a form like Keystone Pro eliminates that, essentially that tendency to skip over things just in the rush of things. So if you think about using Keystone Pro and you go through it, or any other form for that matter that you design, making sure that you're logically moving in a logical progression to meet what is required there. And the evidence-based compliance is that we want to be able to show that we are collecting information and that we are able to demonstrate in a compelling manner that the vendors we're using and the regime we're building, the governance regime we're building around from these vendors, is such that it is clear to anybody looking at it that we know what we're doing. The last thing you want to be in a position is that you look like a fool, because it's just not structured. And, in my experience as an in-house lawyer, and also now in private practices, I frequently am not the lead, but I'm one of the leaders in the process of vendor vetting and assessments. And people look to me, to kind of set the tone of what we're doing. And if we're not setting the tone, somebody else is. And then ultimately we get the question, how did you not know this? So I don't want to get that question. I also want to talk to the board at a level where I am essentially communicating very clearly that I know what I'm talking about. And it's not because I'm a lawyer, it's because I'm, again, basing everything I'm saying on international standards, well-known published regulations. There is no way to argue with what I'm saying that we need to do, because what we need to do is internationally accepted. And I'll say this, I was recently giving a presentation in Bucharest, Romania, and it reinforced, I already knew this, but it reinforced to me again how things like NIST, which we tend to think about as purely domestic in terms of its quote unquote jurisdiction, is actually something that is being looked at in foreign countries. And so what NIST has to say is extraordinarily valuable. I'll say this over and over again. And when you think about how NIST ties to ISO standards and IEEE standards, it's very clear that they're all speaking the same language, and there's a good reason for that. And that all goes back to being able to talk to the board at a level that they understand that you know what you're talking about. Again, that Keystone Pro becomes your script to show that you know what you're talking about, and basically putting yourself in a position where you cannot be challenged. Now, this takes practice. You can't just pick up the form and run with it and say you can't be challenged. There's a lot of other things that you will need to learn about the standards, for example. you need to know what they are. And so it's not just a matter of saying, oh, it's this standard, and you've checked the box and now you're good. I think it's much more than that, but this is a way to start. Otherwise, you have, I think, an overwhelming, daunting kind of challenge on your hands. So let's take a look at the next piece here. So the and I really just want to talk about the realistic controls here, because the Keystone Pro form is really about realistic controls. It's about making sure that you're not asking questions that are just, aspirational. There's this, I've seen this where people ask questions that are like, this is not relevant. This is not getting us anywhere. This is not helpful. This is not moving the ball. It's not going to help our contract drafting. And ultimately, when you think about it, the whole idea of Keystone Pro and the whole idea, and even if you're not using this form, it doesn't really matter. The bottom line is that everything you're doing, the 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 purpose for it is to ensure that you have a way to not only to communicate to the board as and executives, like I've said before, and to regulators, but also when you're writing the agreement. When you're writing, part of effective vendor management is to write agreements that make sense, that they are relevant, that they fit the size of what you're working with. And I do want to shift very quickly here to one thing that I want to make show you in the form, and that has to do with the criticality tier. Here we have the ability to select what type of vendor we're dealing with. So what I want to emphasize here is that the realistic controls are such that if we are dealing with somebody, with a vendor that's mission critical, it's going to be different than a vendor we're dealing with that's administrative, which is a lesser critical type of vendors. Now, not that they're not important, but in terms of risk, mission critical vendors have higher degree of risk, and administrative ones have lower ones. So when you're thinking about realistic controls, we want to be also mindful of what is it that we're dealing with. And I think it's our responsibility as lawyers to ensure that we understand who we're dealing with and why we're doing what we're doing with this particular vendor. Because otherwise it's not a one size fits all type of situation. And I want to make sure that when I am sitting down with my opposing counsel, sometimes, many times, drafting the agreement or working through changes in the agreement, that what I'm asking for is realistic. It's not me, being, some, hotshot lawyer trying to score points with their client. No, I'm just asking for things that should be very obvious. And the reason they're obvious is because they all tie together to the standards and regulations that really, again, they cannot be argued with. So we saw, I already showed you the form, and I want to say again, it is this proof engine. Overall there are 13 scored domains in here, and sometimes I make some updates to the form depending on what I need to do. Like I said before, it's fully customizable, but I try not to change the domains. I tweak parts of inside the domains, but I don't go too far into it, unless it's necessary to create something vastly different. But I don't want to have 50 versions of the forms. It just becomes unmanageable. So one of the things that I try to do there is make sure that I have the ability to create the proof for whatever it is that I think is at hand. Now, with the CPPA, this is what you're looking at. There's nothing else that needs to be changed in the form for the CPPA or beyond the CPPA. So the types of cybersecurity assessments that I think the regulators, the CPPA is looking for, I think that the form you're looking at, the version of the Keystone Pro, is what I would be using for that manner. So we'll go back a little bit quickly back to the form just to look at some of the sections here and just have a little bit of a discussion. So when I'm looking at the section A is pretty much self-explanatory here. And then let's look at vendor profile. And some of the things here that are they're from lessons learned, for example, how many years they've been in operation, uh, what are their primary service descriptors, what kind of revenue do they have, what's the size of this company? These are questions that I've been asked by executives when we're talking about a specific, service that we're going to be bringing into the company. And I, again, don't want to be in a situation. I don't know how long they've been in operation. That's not a good question to be asked if you don't have an answer. You want to have an answer. They've been in business for 10 years. That's a good answer. Or if you say, look, they've only been in operation for 1 year, I don't know if we should use them. That's another good answer, right? You can see how this all creates a script for you to follow. The financial stability and credit worthiness, again, is something that surprisingly to me is something lawyers don't look at. I want to know and I want to be able to talk about the financial stability and credit worthiness of a vendor because um, if they don't have stability in this domain, then they are incapable, in my mind, of meeting the requirements that I need to be able to say they meet. So the financial stability is absolutely critical, and there's all these questions here that relate to that. And I'll explain a little bit more detail what the risk assessments are, because that's very important for our discussion today, especially as it comes to the CPPA, compliance with the CPPA. The governance piece is extraordinarily important also. Without proper executive oversight at the vendor, there is just no way they are going to be able to meet the requirements that we set for them. The risk assessment practice, again, from hard lessons learned doing this, over 2 decades now. How do we get to what we need? There's all these different assessment methodologies. What is it that the vendor is using? I want to be able to answer all these questions. I've been asked the question of what's the vendor risks, what's the frequency of the risk assessments? And again, I don't want to be in a situation where I say, I don't know, because this is important to know. So here we go. We have ways to address that. And then, by the way, I will pause for a second and say that in each one of these, I have the ability to set the risks um, and the control strengths uh, based on my evaluation with the team. And if you do this, you will likely also agree that this is not something lawyers do by themselves. In my experience, I've always dealt with vendors as part of a business team. It's not just me, okay, Iran, you go do this. No, I'm working with a procurement professional team. I'm working with people from engineering. I'm working with people from marketing and people working from finance. It's a team of folks that is gathered around to do this type of assessment. So the risk assessment itself on every one of these pieces is things that is part of a collaborative undertaking. We work together to score these things. So risk assessment here, how important is governance? I can say governance will, just as an example, governance will probably always score a 5, maybe 4, because I just think it's so critical. What is the likelihood that something goes wrong? Yeah, again, it's a matter of discussion with the team, and maybe you decide it's a 3 out of 5. What is the impact? What does that do to us if this happens? What if their governance fails? Well, the impact is going to be big, right? And how do we control that? Do we have any compensating measures within our organization aside from terminating this agreement? What do we do if something goes wrong? Our control strengths maybe are not very good. And you can see here that the risk is high. Now you're dealing with a red risk, which means it's a higher type of risk. And if I scroll down here, you will see that it is already flagged in the risk assessment summary. And below we have a critical risk detected, which is something that I will definitely want to be talking to the executive team when we are looking through this uh, uh, form and are the results of our assessment. I'll just jump down to business continuity and disaster recovery just for time here. Um, Again, very important in terms of what happens if this vendor just isn't able to deliver. So we look at business continuity, which is different than disaster recovery planning, and their incident response capabilities. And I want to make sure that I have all this information in it, because when you look at NIST, when you look at ISO, and you look at SOC 2, this is all relevant information to those efforts. All right. Let's move over back to our PowerPoint. Hopefully nobody's getting seasick as we're going through this. So I think that some of the ones that I focus on in terms of showing the capabilities of this form is when I talk about network access. And you can imagine the CPPA cybersecurity audit talks about the audit itself of your organization, but your organization is dependent on many other vendors, and some vendors will get access to your network. And you will need to be able to determine how much access they get. And the form, the Keystone Pro form, basically captures what type of access the vendor needs. And this is something that you will be able to talk about, because I've also been in those meetings where the question becomes, what kind of access does the vendor need to our system? And people just don't know. Or they say, oh, they need access to everything. Obviously, that's not going to work. So you need to be able to be ready with a quick answer as to what kind of connection they need. It usually will be limited by some time. It's not going to be a forever kind of a thing, right? Or it's going to be limited to certain assets and so forth. In terms of insurance and incidents and history, I do want to go back to the form for that. So let's look at the insurance, and that is up here. So if we look at and by the way, we talked about network connectivity, that's what that is. So insurance coverage and financial protection, here we look at their cyber liability insurance. I've been in meetings where people say, well, we don't have any cyber liability insurance. And I go, really? Well, you better get some. Because I can't go back to an executive and say, oh, they don't have any cyber liability insurance, and get away with that. So that goes there. Then what general liability, professional liability, depending if that's relevant or not. And then what kind of inclusions, the policy expiration date, is there any retroactive date? And then we go back and assess the risk there. And as you can imagine, the risk assessment of the weight of insurance can be fairly large, especially if you're dealing with a tier 1 vendor, which is the mission critical vendor that I was explaining about earlier. So with that, that's our insurance. The cybersecurity audit itself will always center on, the risk assessment, right? And that's where I want to go back and talk a little bit about the risk assessment. And hopefully it's clear by now that when you are reporting back to executives or the general counsel or at a board, depending if it's a large implementation of a system for like a big AI rollout of some sorts, you want to be able to show that we are secure with this vendor or we're not, because this will all tie back to the CPPA cybersecurity audit. If you're not able to go back and say we are going to be compliant, then you're already basically set up for a situation in your cybersecurity audit where you're not going to be able to meet the regulators' requirements. And like I explained earlier, I think, or highlighted earlier, I think that what we're dealing with the CPPA is going to just be replicated across the nation. And so it's a good thing to say we are we are compliant. So let's take a look again at the governance piece here of the form, just to have a good idea of how that part works. And we're looking at sections D and E. So again, we're looking at the governance. So here, when we talk about this, describing the vendor cybersecurity governance structure, one ideal answer that I think you would get here is that the vendor follows the NIST cybersecurity framework. And this makes the discussion a lot easier, but of course you want to have documentation. So it's not just taking the vendor's word for it that, yeah, we follow the NIST CSF. I want to see evidence of that. So it's the proof, right? And that would be a very welcome answer. It's not usually the case. And sometimes they say, well, we're ISO certified. And that's a beauty of an answer. And let me see the certificate, right? So hopefully the certificate is current because you need to recertify. And so just saying you're ISO certified is, while it's good, it's promising, I would not stop there. I would want to make sure that we capture the certificate, make sure it's current and all that. So we describe that in free form. And again, because as I said, we're not working alone. We're working in a team. So I'm working with IT leadership. We work together to flush that out in narrative. What is the vendor cybersecurity governance structure? Some companies don't have a CISO, our Chief Information Security Officer, but they have others with similar roles. And so we want to capture that. Maybe it's a chief information officer, maybe it's a chief data analytics officer that has some of these functions. Not ideal, by the way. And I would actually elevate the risk in the likelihood here. I would elevate that if they don't have what I want to see there. And one of the things I would want for a cybersecurity audit would be to see this, that they have a CISO. And if they don't, then that's a question. Obviously, there's a lot more to this, as you can imagine. Just because somebody has a CISO doesn't mean that CISO is good. You'd want to have some intel on this individual. How good are they? Yeah, just because they have a CISO title doesn't mean that they're any good. And what kind of board level cybersecurity oversight does this company practice? So do they have a board? Hopefully they do. Is the board active in this regard? And that's all governance. If there is no board, then the governance is extraordinarily flawed. And that's a big risk that I probably would say we shouldn't use this vendor. And if they have an ad hoc oversight frequency, that would be a big problem here too. So these all things would be informing how much risk I'm able to assign here. And ultimately, if the vendor's governance is ad hoc, just as an example, my ability to control this is basically zero. And you can see this, the risk just jumped up. So that's going to be very telling here. If your governance analysis is not going well, then you have a problem. Now, in the risk assessment, what is the methodology? If somebody says they're using ISO 27005 or the NIST, the risk management framework here, hopefully it's, quarterly or some other period of time. And what is the, how do they track their risk? How do they measure their risk? What are their risk registers? And then we go in and we start plugging in the risk elements in here. Obviously, their data protection and encryption is also something we need to be looking at. It all ties to risk, right? If they have no encryption right here, none, well, that's going to play right into a very bad risk assessment, especially because we are dealing with personally identifiable information. Otherwise, we wouldn't be really even thinking about the CPPA, right? But if they don't have any encryption, that's a big problem. We have to have a very good answer for why that's the case. And I don't know that, really, to be honest, I don't know that we will have a good answer to that. Now, as we're kind of reaching the end of our hour, I do want to spend a couple minutes here talking about the risk assessment. Um, just to again make sure it's very clear what it is that I'm talking about, because when we talk about weight, likelihood, impact, and control strength, these are all things that we're reporting to the executives, and so we need to. It's very important to understand what we're doing here. So the weight is how important is this particular domain to us, as we saw in governance, critical, right? So that it scores a very high score there. The likelihood, what's the probability of facing an issue? Well, if somebody, for example, in this data protection and encryption section domain, we're seeing that it's they have no encryption. Well, the probability of an issue is very high, right? You don't need to be a rocket scientist to know that. And how severe would it be if we have a vendor that has no data protection and encryption? Is that how severe will huge? Because when you think about it, there is no good way to explain why there was no encryption. If you're dealing with PII and there's no encryption, what is the story you're going to tell? How are you going to explain this? And the control risks are really, at the end of the day, terminating an agreement. I doubt that you will have, maybe we have liquidated damages, or we have some other ways to deal with it. But the control strength at this point are very, very low. And the regulators, I think the CPPA basically comes up back and says, well, you don't have a good cybersecurity regime, so you don't have a good story to tell. So the control strength is basically zero. And so then we have residual risk. The residual risk is ultimately what the executives care about, is what's the bottom line? If we have very high degree of risk and we have very low degrees of being able to control it, our residual risk is very high, as we saw here below in the governance. This is a very high residual risk. It's not the highest, but it's very high, and it's critical. So we already know that we need to be dealing with it in an active manner. So with that, let's move back to our PowerPoint quickly here, making progress. So let's go to, we already talked about this risk scoring math, and then to, oops, sorry about that, the continuous monitoring. Now, one of the things that I've talk to business teams about is that what we're doing here, the entire exercise of this third-party risk management, is a snapshot in time. We will need to evaluate this again at some point. What are the trigger events? What kind of things happen? And the Keystone Pro form helps us with that. We want to detect things that are changing and make an assessment of whether or not we need to go back and revisit this particular vendor. So if there's a litigation suddenly with this vendor, that's a change. That's a trigger change that we need to look into. If there's financial distress signals, if they miss their insurance renewal, things like that. And realistically, we only have maybe once a year the opportunity to run an audit. But if we also come across bad press, that means that this is something we now need to go back and look at. And so one of the things that we are now able to do with Keystone Pro is that we are essentially creating a log of what we are monitoring. And again, this will be important for the cybersecurity audit requirements under the CPPA and other states. When those get rolled out, being able to show change documentation. That things changed, we were alerted to them, we made changes, so our audit results are defensible. They show that we're thinking about this in a systematic way, not in an ad hoc way, and that this compliance mindset is a loop. It's not a one shot kind of a thing. We're following rules, controls, and documenting the proof using the Keystone Pro or any other form that you're using to do this. So this is the contract is we're I already said this a little bit. The contract is worth everything comes into everything funnels into, because ultimately the contract is where we're reflecting the efforts of our intake. So I think one of the important things here is we want to make sure that we have right to audit. And the right to audit, you think about it, yeah, it's a copy paste type of provision. Well, I argue that it should not be, and the audit rights should be something that is carefully reflecting what it is that you found in the Keystone Pro analysis, and if there's any red flags in the heat map, the risk assessment heat map there that I showed you earlier. I'll go back to it quickly here. It's always easy to talk about when you can see something. So if I see that there's a governance, or if there's any other sections in here that are scoring high, I want to be able to go back and say, we are looking at this again. This is triggering a much more a stricter audit provision, because they scored low in governance. And maybe the compensating measure that we say here is that we're going to have a 3-month audit cycle versus the traditional 12 months, and or maybe even monthly. I don't necessarily know that I would ever recommend using a vendor that has that high degree of frequency of audits, because it's also a cost to the company. But the point here is that we want to make sure that if we're looking at audits, that we are doing it in a smart way, that we are our audit rights reflect the risk, and we're not just adopting a risk measure, which is essentially the result of a cut and paste of other contracts that we've used. So I would never want to be in a position to try to defend a 1-year audit when we have clearly identified that this vendor has severe risk factors that would require a higher degree of oversight on this. So the beyond piece here is, again, I want to underscore that we are looking at frameworks and standards that basically drive what we do. That's the beyond, part of the beyond, not all of it, but part of the beyond thing here. Because when I give advice, and it's legal advice, yes, but the legal advice is based on in important parts on what NIST has to say about identifying, protecting, detecting, responding, and recovering when it comes to data security. Again, I need to be able to meet the cybersecurity audit that has been put on me by the CPPA, and with that, I need to be able to talk about in an intelligent, authoritative way about and the NIST framework essentially sets that stage for me, and so do the ISO standards. But the only drawback I will say, just from my perspective on ISO standards, is that some companies don't have the financial wherewithal to certify to ISO. It's a much bigger undertaking, much more formal undertaking than NIST. So I wouldn't disqualify a company just because they don't have an ISO certification, but clearly the Keystone Pro form is directing me to ask the questions, and even if they're not certified to ISO, at least I'm asking questions that are ISO certified type questions that I would be asking. It's one thing not to have the certification, and which may be okay. It's depending completely on your professional judgment in that regard. But sometimes a company can have ISO-like processes and procedures that fill the gap. Again, it's you have to play it each one as they come. But again, the program that we're putting together that gets us ready for that cybersecurity audit that the CPPA is mandating now. This is not just something you should be doing. This is now something that you must be doing. This is how we get ready for that. So that's the beyond, and that's how we communicate to the executives. And again, this puts us in a position where we cannot be argued with just because we are following the best guidelines out there that need to be followed. And why do executives care? Because ultimately, I would say it's the bottom part here, the board part. Executives care because this is now a board level type of issue. Cybersecurity is a board level issue. It's not just an IT issue by any means. I don't know if you have a different experience with that, but my experience is that it is definitely a board level issue. And that's why we have chief information officers, chief data analytics officers, all these data and information type executive roles are coming into play very clearly there. So the executives care about this, and ensuring CPPA compliance is not something that you can just say, well, they don't really mean it. They clearly do. And like I said, I think this is going to be something that's going to be way beyond just the California. So again, what we want to be able to do, just a quick wrap up here, we want to have records that are clear. We want to make sure that we show that we're diligent, that we capture all of this information, that our decisions are made based on facts that we've collected and not a hindsight type of analysis. It's like almost as bad as ad hoc. And ultimately, we want to make sure that we can maintain privilege as much as we can. And that's part of the reason I think using this form by counsel is so important. So the CPPA teaches us basically, if we cannot show this, we did not do it. And I think that Keystone Pro is the way you get there. You never want to be in a situation where you are asked, how did you not know this? And you don't have a good answer. And I'll say it one more and last time, Keystone Pro is the way to make sure that you are not in a position where you cannot answer the how did you not know this question. We don't know everything, but we can certainly follow a very detailed, diligent, highly defensible structure that gets us there. You have my contact information. If you would like to reach out, talk to me about this, do a demo, I'd be happy to. Thank you very much for your time.
Thank you, Ron. We are at time. So as he mentioned, this is his contact information. I just put his email in the chat if you would like to reach out with questions or for that additional demo. And then to reiterate, if you did have a question that you weren't able to submit today, you can find Iran's email in the chat if you would like to reach him. We want to thank you all so much for joining us for another Justia webinar. As I mentioned earlier today, if you're a lawyer attending, don't miss out on the Justia Lawyer Directory. It's a free tool to boost your professional presence. You can claim your profile at lawyers.justia.com to connect with millions of potential clients each month. And you can also explore our newly redesigned listing pages and enjoy new features on your profile, like the FAQ edition, to allow you to answer comment client questions and boost your visibility for AI search results. And if you want even more visibility, you can get our Justia Premium placements, Gold or Platinum, to put you ahead of the competition. You can learn more about those by going to marketing.justia.com. Thank you all so much for joining and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.